You must have heard of Insolvency and Bankruptcy Code 2016. The Parliament has recently passed amendments to the Insolvency and Bankruptcy Code to address delays and improve resolution efficiency. Now, the Insolvency and Bankruptcy Code, which was enacted in the year 2016, provides a time-bound framework to resolve the insolvency of companies, partnerships, and individuals in our country. Now, the objective is to either revive financially distressed firms through a resolution plan or liquidate them in an orderly manner if revival is not feasible at all.
As of December 2025, IBC has facilitated resolution of 1,376 companies, enabling creditors to recover 4.11 lakh crores. So that is the record of IBC, and financial creditors have also seen recovery exceeding 34% of their claim.
Now, the process is overseen by the National Company Law Tribunal. You must have heard of this as well, that is NCLT, and the Insolvency and Bankruptcy Board of India, that is IBBI, acting as the regulator. Now, this Insolvency and Bankruptcy Code, it marked a major shift from the earlier fragmented laws by creating a credit-driven process and enforcing strict timelines for resolution in our country. Now, there have been several issues in implementation of this Insolvency and Bankruptcy Code. And despite such transformative intent, the IBC has faced several operational challenges over the time. The first one amongst them was delays in admission of cases. Now, this has weakened the time-bound nature of the process altogether. Also, the backlog of cases in tribunals has increased resolution timelines beyond the prescribed limits. See, that was the intent of the Insolvency and Bankruptcy Code, that all this insolvency and bankruptcy proceedings will be completed in a time-bound manner. Actually, it will help the banks, it will help the country, it will help the economy, plus it will help ease of doing business in our country as well. Also, recovery rates for banks, they have remained modest in many cases. And these challenges have reduced the effectiveness of Insolvency and Bankruptcy Code and highlighted the need for further reforms. Which is why these reforms have come. And which is why today's topic of discussion would be the Insolvency and Bankruptcy Code Amendment Bill of 2026. Hello, my name is Preetpal Singh and you're watching Perspective. Now, this IBC Amendment Bill has been passed to address structural gaps in insolvency framework. The amendments aim to speed up the resolution process and introduce new mechanisms such as out-of-court resolution. It also includes group insolvency and cross-border insolvency as well. And one of the key changes relates to the faster admission of insolvency applications, again solving the challenge before. The NCLT is now required to admit applications once a default is established without any additional discretionary conditions. See, always understand, whenever discretion comes into play in bureaucracy and governance, red tapeism always follows. Which is why this additional discretion needs to be done away with and e-governance needs to be promoted. Now, a major reform is the introduction of the creditor-initiated insolvency resolution process. We call it as CIIRP. And this allows specified financial creditors to initiate insolvency proceedings outside the traditional court-driven process, provided at least 51% of the creditors must agree. It's a path-breaking reform. And the amendments also incorporate recommendations of the Select Committee as well, which suggested measures to reduce delays and improve oversight. And all these measures includes stricter timeline for the appellate decisions and enhanced powers for the regulators as well, so that IBC can be made much more effective. Also, one more important reform is the introduction of group insolvency and cross-border insolvency frameworks. Now, these aims to address complexities arising from interconnected companies and international operations as well. And this particular amendment also seeks to reduce conflicts of interest by preventing resolution professionals from acting as liquidators in the same case itself. Further, the law replaces certain criminal penalties with civil penalties for procedural violations, also recognizing that delays or non-compliance may not always involve malicious intent, which is why these reforms, these amendments are very, very critical. Now, let us understand what are the key implications of these amendments. Now, the amendments are expected to significantly improve the efficiency of India's insolvency framework that is given. It will lead to faster admission of cases, and it will reduce initial delays, which have been the major bottleneck of Insolvency Bankruptcy Code. Also, the introduction of out-of-court mechanisms. It will provide flexibility and a reduced burden on the tribunals. And also, group and cross-border insolvency provisions. It will align India's framework with the global best practices as well. The reforms are also likely to improve investors' confidence by ensuring predictability and reducing litigation delays in our country. Which is why Insolvency and Bankruptcy Code is important. These amendments are even more important whatsoever. Now let us understand what is the performance of IBC so far, which means how Insolvency and Bankruptcy Code has performed so far in our country. See, the IBC has achieved notable outcomes since its implementation. As of December 2025, around 1,376 companies have been successfully resolved under the framework. Creditors have recovered approximately around 4.11 lakh crores, and financial creditors have achieved recovery of over 34% of their claims. Now, these figures indicate that while Insolvency and Bankruptcy Code has improved recovery and credit discipline, there is still scope for enhancement. Which is why these recent amendments, they represent a step towards making insolvency framework more efficient and responsive in our country. Sustained improvement will depend on strengthening institutional capacity, especially the tribunals, which is why regular improvements in IBC is very, very important. Also, reducing litigation and ensuring strict adherence to the timelines will be critical to implement these amendments properly. And also, what we require is further clarity in cross-border insolvency rules, which will be necessary for effective implementation, and overall, a balanced approach that will prioritize resolution over liquidation, and it will help preserve enterprise value and support economic growth in our country. Now, this is what we have talked about Insolvency and Bankruptcy Code, Amendment of 2026. But let us now go back and let us understand IBC at its core. See, Insolvency and Bankruptcy Code, as we all know, was enacted in 2016. Now, it was based on the recommendations of T.K. Vishwanathan's Bankruptcy Law Reforms Committee, which was formed in 2015. Now, this IBC network, that is Insolvency Bankruptcy Code network, has created a unified, time-bound and credit-driven framework, which I already told you, for resolving corporate distress in our country. And also, if you remember, during 2016, it was introduced when NPA, non-performing assets, were rising, and older mechanisms like our SARFAESI Act or Lok Adalats were proving ineffective and slow. Which is why this Insolvency and Bankruptcy Code, this ensures that when a business becomes sick and defaults on its loans, creditors can recover their value very, very quickly. Either through a resolution, which means restructuring, sale to the new owners, or liquidation. And its core objective is to prevent the loss of asset value, maintain a healthy credit cycle, and free up the stuck capital to keep the economy more vibrant. And as we have already discussed, the regulatory authority for IBC is Insolvency and Bankruptcy Board of India. Again, this IBBI is a statutory body established under the Insolvency and Bankruptcy Code of 2016, and it is responsible for formulating rules and regulations for insolvency regulation in India. And it comprises of members from Ministry of Finance, Ministry of Corporate Affairs, and the Reserve Bank of India. Also, there is an adjudicating authority as well. In the Insolvency and Bankruptcy Code, the adjudicating authority for corporate persons is the National Company Law Tribunal, while the individuals and firms, for them, it is Debt Recovery Tribunal, DRT. And also, there is a committee of creditors as well. And it is a decision-making body under the Insolvency and Bankruptcy Code 2016, which composed mainly of financial creditors. And its primary role is to evaluate, approve, and reject resolution plans for a corporate debtor undergoing the corporate insolvency resolution process. Now, this is a lot of detailed information about Insolvency and Bankruptcy Code. But we also need to understand about the Insolvency Bankruptcy Code process, that how a company who's in this IBC, what processes a company can go through. So the first step is triggering insolvency. In this, a financial creditor, operational creditor, or the debtor may file for insolvency on default. Second step is admission by the National Company Law Tribunal. Now, the NCLT admits or rejects the application within 14 days. And once admitted, the formal CIIRP starts. Now, the third step is appointment of IRP. So, National Company Law Tribunal then appoints an interim resolution professional to take control over the country, secure its assets, and collect financial data. And then comes the another step, that is the fourth step, which is formation of COC. Now, the interim resolution professional, it forms the committee of creditors, that is COC, of financial creditors, which decides on the revival or the sale of the company and may retain or replace the IRP. And then comes the fifth step, that is resolution plan. Now, resolution plans are invited, evaluated, and approved by the COC with 66% of the votes. Failing this, liquidation follows. And then comes the NCLT approval. Now, the approved plan is submitted to National Company Law Tribunal and it is submitted for the final clearance, making it binding on all the stakeholders. And the timeline is that CIIRP must be completed within 330 days, ensuring faster recovery and preventing any kind of a value erosion. Now, this was the complete resolution process under the Insolvency and Bankruptcy Code. Now, there were several regulatory provisions for asset recoveries in India other than the Insolvency and Bankruptcy Code as well. One amongst them is SARFAESI Act of 2002. Now, the full form is the Securitization and Reconstruction of Financial Assets and Enforcement of Security Interests Act of 2002, which in short we call as SARFAESI Act of 2002. Now, it is a core law empowering secured creditors, mainly the banks and the financial institutions, to recover dues without any court intervention. And this particular act, it enables banks to recover non-performing assets efficiently by promoting asset reconstruction companies, ARCs, and securitization companies. Now, the question would be, what do you mean by this asset reconstruction company? Again, this is very, very important. Asset reconstruction companies is a special type of financial institution that buys the debts of the banks at a mutually agreed value and attempts to recover the debts or associates its securities by itself. Now, this concept of ARCs was introduced first by Narsimham Committee 2 of 1998, leading to the establishment of asset reconstruction companies under the SARFAESI Act of 2002, which is why this SARFAESI Act of 2002, asset reconstruction companies, and Insolvency Bankruptcy Code, all these three are very, very integral for resolution process in our country. Now, since we have discussed a lot about Insolvency and Bankruptcy Code, let's quickly see and glance through the significance of IBC in our country. See, first, very integral significance is that it has led to a shift in the borrower's behavior in our country. Several promoters, they now avoid defaults to prevent insolvency, preserving control and reputation of the company. Also, other than that, it has improved credit discipline also in our country. Enhanced repayment and early resolution, it has helped reduce the gross NPAs from 11.2%, which was in financial year 2018, to 2.8%, which is in financial year 2024. Also, it has led to better corporate governance. See, several result firms, they show more independent directors, professional management, and improved compliance. Again, IIM Bangalore study talked about this, and which is why another benefit is the lower cost of credit. See, clean balance sheet and restructuring post the Insolvency and Bankruptcy Code, it has reduced lenders' risk in our country, leading to a 3% average drop in the borrowing costs for stressed firms. And the successes of the Insolvency and Bankruptcy Code is a testimony to its performance. See, Insolvency and Bankruptcy Code, some of the performance I've already told you, but it accounted for 48% of the total bank recoveries. SARFAESI, it accounted for 32%, debt recovery tribunals accounted for 17%, Lok Adalat contributed for around 3% for the financial year 2023-2024. Now, this makes Insolvency and Bankruptcy Code the largest recovery mechanisms for the banks in our country. Also, realization has exceeded 170% of the liquidation value. And there have been high pre-admission settlements under the IBC. Around 30,310 cases were settled before formal admission to insolvency proceedings as of December 2024. And it covered defaults worth around 13.78 lakh crores, reflecting the deterrent effect of Insolvency and Bankruptcy Code. Also, comparatively, it is offering a speedy resolution mechanism. The Standing Committee on Finance report of 2021 noted that the time taken to resolve insolvency has reduced from 4.2 years to 1.6 years between 2017 to 2020, again a major feat. And also, IBC has led to attracting foreign investments due to improved investor confidence by providing improved recovery prospects in our country. And it has also promoted a credit-centric A creditor-centric, so to say, approach by providing a clear hierarchy of claims to be settled and providing a structured mechanism for the resolution process. Also, it is promoting a culture of entrepreneurship by providing exit mechanisms for failed businesses and encouraging entrepreneurs to take calculated risks. So, which means IBC has been successful. It has played a very significant role in the resolution process for the banks and the financial institutions in the country and helped the overall economy to be more vibrant. But still, there are several challenges for this and under this Insolvency and Bankruptcy Code. One amongst them is still delayed resolution. See, despite COC's approval, resolution is often delayed due to insufficient judicial capacity in our country. Around 78% of the ongoing corporate insolvency resolution process, that is CIIRP cases, exceeded the mandated 270-day timeline as of March 2025. This is something which I've told you earlier as well. And also, even after the resolution plan is approved and implemented, stakeholders often initiate legal challenges. Now, there are several framework gaps for emerging business model as well, which IBC lacks. It lacks provisions to handle complexities in new age firms, resulting in poor resolution, poor outcomes for startups and tech-driven enterprises. And there have been several unaddressed aspects in the Insolvency and Bankruptcy Code. For example, valuation and transfer of intellectual property rights, treatment of employee dues, and ensuring technology continuity, example licenses, data access, remains unresolved in the Insolvency Bankruptcy Code framework, especially for the startups. But does this mean that Insolvency and Bankruptcy Code is not effective? The answer is a big no. IBC has been a major path-breaking reform in India's economic history. Alongside in the last 10 years, alongside GST, IBC has been the second biggest economic reform initiated in our country. And as I've already told you, it has significantly reduced the resolution time period for the companies in our country, which is why it has made ease of doing business very, very effective, very efficient, and very robust in our country. What we need to ensure is that IBC process becomes even more smoother. And these 2026 amendments, which have been passed just recently, it upholds to what they are meant to, and insolvency processes in our country becomes even more efficient. And our country becomes the best country to conduct businesses anywhere in the world. I hope you gained a new perspective and you learned a lot about Insolvency and Bankruptcy Code 2016. Do let me know in the comment section what are your views or your suggestions of how IBC can further improve itself. I'll be very happy to read your comments. All the very best. Please have a beautiful day. Thank you.